There are many misunderstandings about how VAWA works. I'm going to do my best to clear those up today. VAWA stands for Violence Against Women's Act. So often, people think this is something only women or battered wives can get. On this video, I'm going to explain how you don't have to be physically abused to qualify, and you don't have to be a spouse to qualify. You don't even have to be a female to qualify. VAWA has a couple of very important differences when you receive it, when you compare it to other visas. Keep watching this video to find out more.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
I'm Andrés Mejer, an immigration attorney based in New Jersey, but I help clients all over the US and across the world. I'm an author, and if you'd like a copy of my book, drop a comment below saying book, and we will contact you about how to get that. I'm also a speaker and an immigrant. Like I said, today we're talking about VAWA. Well, what is it? VAWA is the Violence Against Women's Act. VAWA became law in 1994 by President Clinton. The current president almost ended it, but despite his efforts, it is still valid today. VAWA allows an abused spouse, male or female, a child, male or female, or a parent, male or female, to confidentially apply for a visa and then a green card if their abuser is a US citizen or lawful permanent resident, otherwise known as a green card holder. I just pointed out 3 times one of the biggest misconceptions of this act. It is a benefit that both males and females can use in order to obtain a green card. Yes, males can also be victims of abuse. The second incorrect belief is that it's only for a battered spouse. That is simply not true. Children and parents can also apply for a green card under VAWA. Now, if it's a child, must be under 21 years of age and unmarried. However, if the abuse was the primary reason for the delay of filing for VAWA, then a child who is over 21 but under 25 can still file. Also, parents of US citizen children whose children are at least 21 years of age or older. So point of it is, it could be a spouse of the abuser, you could be the child of an abuser, or you could be the child of an abuser. Either one of those would qualify, irrespective of whether it's a man or a woman who's applying. VAWA can be applied for confidentiality. This means that your abuser, spouse, child, or parent, does not need to know that you are applying. You can and should use a different address for your application. All government agencies are told they legally cannot disclose your VAWA application. You can also file for your VAWA if you are divorced from your abuser, as long as you filed within 2 years of when the divorce was finalized. So if you're divorced in January 2021, you must, January 9th, let's just say, you have to file for VAWA before January 9th, 2023. You don't need to stay in an abusive relationship in order to get a green card. That's what VAWA was created for. Now let me clear up a couple of things. 1, if you are afraid for your life, there are safe places you can go. If you call the police, they can help you find a shelter to stay, and they will not report you to ICE. If you're in immediate danger, call 911 regardless of your immigration status. If you are living or staying with your abuser, be aware that he or she could monitor your phones and computers. Be careful what you say and what you do on your phone and your computer. Protect yourself. Let's talk about the requirements for VAWA. Who can apply? Well, first, the abuser is or was a US citizen or green card holder. You can file even if the abuse occurred before the abuser became a citizen or lawful permanent resident. If the abuser lost his, usually it's green card, but it could be citizenship if he got it through fraud, you must file within 2 years of the abuser losing his status. Second, who can apply for VAWA? If you are an abused spouse of a green card holder or US citizen, Only for marriage-based VAWA applications do you need to show that the marriage was entered in good faith. So one way that you qualify, one person that can file, is if you're married to the abuser. Another way is if you're child of the abuser. Now, it could be one of your parents, or it could be a step-parent because they married your mom or dad. If you are a child of the abuser, you must be under 21 years old when you file. Unless you qualify for the exemption mentioned before, you could file up to when you're 25 years old, but you need to show that the delay was due to the abuse. You must be a child of the green card holder or U.S. citizen. Like I said, it doesn't have to be biological child. You could be adopted. It could be a step-parent relationship, but as immigration defines it, has to be your parent. You're the child of an abuser who lost his green card because of domestic violence. So here we're talking about your abuser had legal status. Let's just say stepdad married your mom and then committed domestic violence and was arrested, was convicted, and because of that lost his green card. You still qualify for VAWA as long as you file within 2 years of when he lost his green card. If you're a child, you also can't be married. You have to be single. If you are a parent of the abuser, again, same scenario, could be stepchild, does it not have to be biological child of yours. But if you are a parent under the terms of, as immigration defines it, you're a child who abused you, your child abused you, is a U.S. citizen, so it's only U.S. citizen for this circumstance, and you are over 21 years old when you file for VAWA. So first, we spoke about the relationship between the abuser and you. Second, we talked about who qualifies, parent, child, spouse of the abuser. Now, third, you need to have suffered extreme cruelty and or battery caused by your relative abuser. Again, spouse, parent, or child. Let's talk about the types of abuse that qualify under VAWA. Let me give you some examples. One of the most important things to understand is that you do not have to be physically injured in order to qualify for VAWA. Second important thing to understand is that you do not have to have a police report to prove that you were abused physically or emotionally. I mentioned before that you need to be a victim of battery or extreme cruelty. Battery in the United States is physical violence. It could be hitting, slapping, pinching, kicking, choking, or otherwise hurting you or your minor child. They could use something else to hit you. It doesn't have to be just their hands. They could throw something. They could use a knife. They could use a weapon. You can also be threatened with acts of violence. Saying, "I'll kill you," is considered abuse in the US. Also, if your abuser threatens your children, your family, your friends, or even your pets like your dogs, this might also be considered abuse. Social isolation or forced detention is another type of abuse in the United States. Examples could be taking your car keys, not letting you get a driver's license, so you can't leave the house. Maybe they don't let you take an English class or go to church or other social activities. They tell you who you can or can't see. Psychological or sex abuse or exploitation is another type of abuse, and that includes rape, molestation, incest if the victim is a minor, forced prostitution. All will be considered acts of violence. Another example is intimidation and degradation. This is when an abuser might intimidate you, humiliate you or your children. Examples could be non-verbal warnings like clenching your fist, or a look, holding a weapon in a threatening manner, or threatening even, "I'm going to call ICE unless you do the following." All of those can be examples of abuse. How about economic abuse? The abuser might refuse to give you money or may keep the money you earn. This is very common for male victims. They may keep you from looking for a job or do something so that you get fired from your job. Verbal abuse also qualifies, yelling, insulting. Again, it needs to rise to a certain level, so it's never just one of these. It's usually a combination of them. Other abusive acts may also be acts of violence under certain circumstances, including acts that in and of themselves may not appear violent, but that are part of an overall pattern of violence. Basically, immigration is going to look at a totality of the circumstances. Was there physical abuse? Was there emotional abuse? How do you prove what happened? You have to look at all of it. So, first we looked at who can file. Second, what's your relationship to the abuser? Second, we talked about what are the requirements for each category, meaning if you're a parent, a spouse, or a child of an abuser, what do you need? How do you show that? Now, then we spoke about what is extreme cruelty or battery. Fourth, I want to now talk about, you need to have lived with your abuser. That's either the spouse, the parent, or the child. The abuse must have taken place while you lived with the abuser. There is no specific length of time that you must have lived with the abuser, and you don't need to still be living with the abuser when you file the petition. But if you never lived with the abuser, you're going to have a really tough time qualifying. You're probably better off not filing at all for VAWA. Fifth, you have to be a person of good moral character. This is immigration's catch-all. This is where they could say, yes, you were a victim, but because you just served 20 years in jail, the fact that someone mistreated you does not overcome the harm you did to others. So it's a balancing act. Public charge that came into effect February 2020 does not apply to VAWA applications, and you don't need to file an affidavit of financial support. That's Form I-864 with your VAWA application. If you are under 14 years of age, it is presumed that you are a good moral person. In other words, you don't need to prove it unless you have some negative factors, in which case that presumption goes away. VAWA can help you overcome issues in your past that typically make you ineligible for a green card. If you recall, on these videos I typically talk about there are 3 fundamental questions that we need to answer for every consultation. 1, do you have a path for legal status like VAWA? Second, is there something in your past that might disqualify you? Maybe an order of removal, maybe certain criminal activities. We're going to go into that shortly. And third, is there a way to fix it? Well, VAWA includes a waiver. When you receive your green card through VAWA, it is a 10-year green card rather than a conditional green card that you otherwise would get if your spouse had filed for you. Every person who gets a green card must be admissible to the U.S. That means you must be eligible to change your status from whatever it is to a green card holder. If you are not admissible because of something in your past, you may be eligible for a waiver, and VAWA includes one. VAWA allows you to apply for a waiver with the application when you would otherwise be inadmissible. You must show that you or a family member will suffer extreme hardship if the waiver is not granted. Now, usually this hardship is only to your family member, but for VAWA immigration, for VAWA applications, they will also consider hardship to you and only to you if that's the only avenue. Waivers can help you fix issues like unlawful presence, permanent bar, orders of removal, fraud, crimes, and health reasons that are often grounds for being ineligible. I'm going to explain a little bit about each one of them. So first, unlawful presence. This is where you are in the U.S. without legal permission. It means you either entered legally and overstayed, or you entered illegally to the U.S. Permanent bar. This is where you were in the U.S. without permission for over a year. You then left or were deported and re-entered the U.S. illegally and without first having filed and gotten an approved waiver. Cancellation of removal. VAWA cancellation of removal. If you are in removal proceedings, it means the government is trying to deport you, you may be able to qualify to stop the proceeding through a VAWA cancellation of removal. Now, we're going to be talking about cancellation of removal in the coming weeks, so stay tuned. We're going to do a deep dive on what is cancellation of removal for green card holders, cancellation of removal for those that don't have a green card, and cancellation of removal for VAWA scenarios. So we're going to talk about that in the future. But in the meantime, if you are in removal proceedings, we highly recommend you talk to an immigration attorney today. Don't wait, because you may miss an opportunity for VAWA, particularly if you're already divorced and then you only have a 2-year timeline. Now, so we talked about unlawful presence. So these are circumstances that VAWA waiver will allow you to overcome. Unlawful presence, permanent bar, cancellation of removal, fraud. If you applied to an immigration agency and you lied to it, whether intentionally or otherwise, that fraud can make you ineligible. Let me give you an example. Let's say you filed to enter the United States, you applied for a tourist visa, and in that visa you said you were married when you weren't, or you said you were single when you were actually married, or what have you. But you lied in that application. Your application was approved, you entered the United States, and now 10 years later, you're filing this VAWA application. Well, that fraud could make you ineligible, but under VAWA, there's a waiver for it. Some health issues also can cause problems, and it can make you ineligible to admission to the U.S. For example, gonorrhea, leprosy, syphilis, or tuberculosis. Also, certain criminal acts that would otherwise make you inadmissible are eligible for a waiver under VAWA. Could be aggravated assault, DUI, drug possession, shoplifting. Again, those are just some examples. You have to look at under the totality of the circumstances, see if the individual crime makes you ineligible, or it might just make you not be a good moral person. If it rises to the level, depending on the severity, you might need to file a VAWA waiver for that ground of inadmissibility. Having a good immigration attorney can make the difference between any waiver and your VAWA application being approved. Especially for the waivers, you have to make a legal argument for them in order to be granted. And it's important to have someone who knows what to do to help you out. Question I get all of the time: how much does it cost to get a green card through VAWA, and how long does it take? Now, we start with the 3 questions that I just went over with you, and we create a plan before we accept you as a client. We only take on clients we can help. So, do you have a path for a green card like VAWA? Is there something in your past that can disqualify you? Well, we just talked about several of them: multiple entries, unlawful presence, permanent bar, criminal charges, in removal proceedings. So, and 3, can we fix that problem? VAWA has waivers, but sometimes it might be a motion to reopen, it might be a post-conviction relief motion, or a waiver. Because we focus on these questions, 2 clients who are both filing for VAWA might have 2 very different costs. In general, here's how we look at immigration fees, whether you're filing for VAWA or for your green card through VAWA. Either way, there's an application that you pay for. We typically charge between $6,000 and $9,000 for the green card or the VAWA petition, depending on the issues and the complexity. VAWA is Form I-360, and sometimes we can also apply for your green card using Form I-485 at the same time. When you do it that way, you're gonna get work authorization faster, and you will get your green card faster. But it depends on what the status was of the abuser. Were they immediate relative or weren't they? Were they a U.S. citizen or were they a lawful permanent resident? Sometimes you can only file Form I-360 and wait for a visa. In other circumstances, you can file for both at the same time. Now, so first is there's a path. There's a petition with supporting documents that we need to present, and there's a cost for that. Second, do we need to order documents from immigration through the FOIA process for prior border contacts, deportations, prior petitions? The example I just gave where you lied applying for a visa at the Department of State in order to enter the U.S. legally, well, we may need a waiver for that. We may need to order, so that means we're going to order a copy of those documents from the Department of State to make sure that we have everything that we need in order to help you. Do we need to order copies from criminal courts and a background search from the FBI? We typically charge $1,000 for the FOIA and the criminal background search per person. So it wouldn't be VAWA husband and wife, because otherwise that's not VAWA. But let's say it was some other path. Let's say your child is filing for you and your husband to get your green card. Well, we might have to do a background search for both of you, which would be $1,000 for each of you. If there's something in your past that makes you ineligible, we have to look at how can we fix it. Sometimes it's a waiver, sometimes it's reopening criminal case, sometimes it's reopening the removal order, or refiling for certain relief. the cost really varies from $3,000 to over $15,000. It all depends on the severity of the charges that you faced. If you killed someone, that's going to be a much harder scenario than if you were in a bar fight 10 years ago. So are you applying just for yourself, or are you also trying to achieve legal status for your kids? Are they all in the United States, or is it mixed? Some are here, some are abroad. We typically charge a nominal fee to include your kids of $500 to $1,000. If they have the consular process, it's an additional fee for that, but it's only after the VAWA is approved. Do they need a waiver? Again, that would be an additional fee, but that's usually after the VAWA itself is approved. It's really rare that a minor child needs a waiver because usually they don't have criminal conduct, they don't have orders of removal. So it's rare, but every circumstance is different. You almost certainly will have an interview before a USCIS official, and we strongly encourage you to bring an attorney with you, because if you are denied, you're going to be placed into removal proceedings. We typically charge $1,500 to attend the interview with you if it's in New Jersey. We will prepare you for the interview no matter where you are, but not every place in the country can we be there with you. Every one of these things has a cost. It's for this reason that my assistants can't give you a price on the phone. It requires the knowledge and experience to figure out what needs to be done and what we charge for each of those services. Today, VAWA is taking anywhere from 1 to 3 years to get approved, depending on whether the abuser is or was a U.S. citizen or lawful permanent resident. It takes longer if the abuser is or was a lawful permanent resident, because you're going to have to wait for a visa to become available, as you would if the abuser was applying for you. If you already have your VAWA I-360 approved, or your abuser is or was a U.S. citizen and the visa is immediately available, then you can file for your green card at the same time, the I-45, at the same time as you file the I-360. If we helped you with the I-360 in the past, then we likely already ordered your background search, and you're not going to need to do it again unless you've been charged with any crimes or you didn't request it in the first place. Maybe you didn't do it with us, maybe you did it with prior counsel. The petition itself usually varies from $3,000 to $6,000 for Form I-45 and associated forms and proofs. Each member of your family will need his or her own form. We do discount if we're filing for multiple filing members. They're usually derivative, and it's much cheaper. If you have an interview, we charge an appearance fee of $1,500 to go with you at the interview. We will prepare you whether we go with you or not. At the green card stage, you really shouldn't need any waivers, because all of these grounds of inadmissibility should have been dealt with when you filed the I-360. However, if there are new issues or you didn't properly address them at this stage, the cost is $3,000 to $6,000. Again, normally this is not the time that you're doing an additional waiver. As you can see, the fees vary dramatically depending on your situation. You don't need to worry, because we offer payment plans. We also offer discounts for those who pay in full. We have discounts for repeat customers. So if we helped you with your VAWA application, you come back for your green card, you're going to get a discount. The more money you bring with you to your consultation, the higher the possibility of getting a discount on your immigration case. Now, we give your case the priority that you do. So the sooner you pay for the fee for your case, the sooner that it's going to get filed. We typically need several weeks once we have all the documents and you have answered our questions and you have paid in full for us to prepare the petitions and to file your case. The more money you bring with you to start your case, the lower your payment plan will be, and the faster your case will be filed. Now, here's a common question or a misunderstanding. How is VAWA different than a U visa? Often people discuss U visas as if they are interchangeable with VAWA, which is not the case. So while applicants for a U visa and VAWA are both victims, they're not the same type of victims from the same person. So let's talk about that. A U visa abuser does not need to be, so the person that attacked you or that hurt you does not need to be a citizen or lawful permanent resident. In a VAWA context, they also have to be related to you. It has to be your spouse, your parent, your child. Not so for a U visa. You don't need to know the person at all. A huge difference under VAWA is you are applying for your green card. First and foremost, For a U visa, you're applying for a visa which you must then have for 3 years before you can apply for your green card. So a U visa will result in a green card and will result in citizenship, but in the VAWA scenario, it's typically faster. VAWA requires proof of harm, but at a lower level than what's needed for a U visa, which requires substantial physical or emotional abuse. You do not need to cooperate with law enforcement for VAWA. That means you don't even need to call the police. Even if you didn't report a crime, you could still qualify. There are no yearly limits on how many VAWA visas are issued. U visas, however, they only give 10,000 a year. Quick recap. VAWA is for victims of abuse. This includes men, women, children, and parents, both male and female. If you are approved for a VAWA, you are given deferred status from deportation. Depending on your abuser status, you may get work authorization immediately, or you may have to wait until after your VAWA is approved. Similarly, you can either immediately apply for your green card, or you may have to wait until a visa becomes available, depending on your abuser status. You will receive a permanent 10-year green card when you are approved. We have helped clients apply for VAWA and their green card many, many times. We would love to help you as well. Please call our office to see if you qualify for a no-cost consultation. Please share our videos with your friends. Thanks for watching.